Hey there, Attorney Peter Olson here. Just wanted to get going with the webinar for today. I'm sure some people usually join a little bit after the start time. I've got about 12:03 here. I think you can send me a message if anybody's having any audio trouble or things of that nature. Do these semi-regularly, but I still don't feel like I'm an expert on GoToMeeting and the back end of using it. So yeah, just a snippet about myself and my history. I'm gonna put my webcam on here for a second too so you can see me. One second. Yeah, Peter Olson here, Chicago Family Law Group. I'm a pro-family divorce and child custody attorney. I am a managing partner at a three-lawyer law practice here in downtown Chicago. And yeah, we're three attorneys, one full-time support staff, and yeah, all we do is represent people in divorce cases and what we would call parentage cases or child custody cases, where you have the exact same child-related issues, but you have people out having children outside of marriage. So really, that's all we do. And then sort of, you have a lot of, surprisingly or not, you have a lot of sort of what you would call post-divorce or post-custody issues in those two cases. So really, we're really focused on what we do. I mean, to me, in business and in lawyer land, you know, you need to be narrow what you're doing. You can't be an expert at, you can't be an expert at 75 different things. So we keep it pretty narrow in terms of what we do. So we can be good at what we do, right? I've personally been doing this all for about 13 years, and I told you a little bit about the rest of our team. We have a nice little mix of less experienced, more experienced, good customer service people, and things of that nature. And yeah, I mean, here's our website. I mean, just as an FYI, you can always make an appointment right here. We do always do like a free initial consultation, and you know, we do like a monthly email blast as well, if any of that stuff's of interest to you. So let's get going with these slides. I've actually never done this specific presentation before, and I'm not totally sure. I always budget for an hour, and we'll fit it in within an hour or less. But other than obviously a little practice run and a little tweaking, haven't really done this package of slides before in any of these quarterly webinars. So yeah, I just entitled this 8 Things to Consider Before Filing for Divorce in Illinois. Right, I think it speaks for itself. And yeah, just sort of go through about 8 different questions that people just sort of need to think about in advance, because this is how I think, and this is true probably about a lot of what you might think of as bad things in life, right? Whether somebody has a home in foreclosure, whether they're thinking about a divorce, whether it's like, I'm trying to lose weight in 2016. These might not be like the best things that you want to be involved in, but within the fact that you know, maybe you are going through a divorce, or it's something that must have to happen, it's a big circle of, okay, you're going through a divorce, you're going through a foreclosure, you had a parent die, or you know, just some of these things that we associate as negative things. But within the circle of a divorce is happening, there's a huge continuum of, here's the best, most efficient, and smartest way to handle it, versus here's the worst, least efficient, and let's be honest, just sort of dumbest, most wasteful way to handle it. And I think that's what people sometimes they sort of get foggy on, is where they just sort of lose their focus. because it is probably a negative thing, and maybe they're emotional, and their judgment sometimes is clouded. But there's a huge continuum of options within the broader idea of going through a divorce, and that's sort of what I'm trying to get at today is, how to approach it in an intelligent and the best way, generically, and the best way for you specifically. So here's just a disclaimer about just the idea that I'm not your attorney. Somebody becomes a client of ours, basically, right, by signing an engagement agreement with our firm, and typically paying us some money too. So just coming to this webinar is more of a general informational sort of a program that we do pretty much on a quarterly basis. So here's just sort of the first question I'm going to answer. Is your marriage actually dead? Obviously a no part of that and a yes part of that. Because I'm really, although professionally I'm in the business of involving myself in people's marriage difficulties and divorce in terms of the legal issues, we're definitely really careful about not encouraging divorce because, I'm happily married. I'm trying to build a great marriage, myself. And broadly, I think sometimes people pull the trigger too quickly on divorce and don't know of ways to sort of get themselves out of what might be, maybe this has to be going down the divorce road, but maybe it doesn't. And just thinking about counseling options, thinking about therapy options, thinking about, and this is actually a strategy that sometimes we use legally, is what I call our protect and delay strategy. Because believe it or not, there are a number of people I can think of just in recent years, within the last year, where one of the spouses filed for divorce, but then the spouse who then became our client did not want to be divorced. And this is generally what we do when somebody comes to us with that. I can think of the exact person who I'm thinking about. It's a woman who I went to church with, or actually sort of went to the same church as I did, and didn't really know her personally, but that's how she knew of us and got referred to us as a law firm. And she didn't want to be divorced. Bottom line, they had a young, cute little girl, maybe 3 years old. And this is really what we did. And when I say protect and delay, it's like this. I'm not a marriage counselor. I'm not a pastor. I'm not a psychologist, this sort of thing. That's really not my skill set. Although obviously I'm doing some counseling and I have some skills in that area. That's not what I am professionally. Professionally, I'm an attorney and I'm sort of involved in the legal part of it. But in the legal part of it, it's really pretty easy to take 6 months, 9 months, where I could say to a client, we can avoid a divorce from happening for 6 months to a year just by just sort of strategy and stuff within the court system. And if you don't want to get divorced, you put in the effort in terms of how you're behaving outside the court system, attempts at reconciliation, therapy and things of that nature. So that's just one thing I would mention. If somebody's basically saying, I don't want to be divorced, that's sort of what we typically do, is what we say, we can buy you 9 months of time, but you have to work on your marriage outside the system. And then I guess on the yes side of it is simply sort of broadly what we're talking about today is are you prepared in terms of emotional, non-legal support systems. Actually a good point to take, because, and I think I have this later in a slide, is your lawyer sort of shouldn't be all that. Your lawyer should be legal strategy and things like that. Therapist, close friends, pastor, that kind of thing. That should be more your emotional support and your sounding board, because one of the negatives, that we get sometimes, and it's not that I'm not sympathetic or don't have some tools to handle sort of the emotional stuff. Of course I do. I mean, I'm a human being, right? But is really, it's just sort of an inefficient use of your lawyer to be that sort of sounding board therapy person when they should be, the lawyer person. Frankly, it's just time issue and money issue. That's not the best use of your legal team. And just general preparation, right? Um, I said up front, and I'd mention again, and honestly, if you looked around beyond, my law firm is, do a couple free initial consultations. Um, I would say it's sort of a 50-50 sort of business decision, but a lot of good family law firms do a free initial consultation. Take advantage of it. I mean, I think about half of the firms out there do that I'm familiar with sort of in the Chicago market. Meet with 1 to 3. I mean, it's probably not something you need to meet with 10 people, but you should meet with 1 to 3 because within the circle of the good family law attorneys, sometimes it's just sort of a personality match, sort of what flavor do you like? I mean, to me, there are two critical things in selecting a family law attorney are, excuse me, just have a little bit of a cold. Is the law practice focused in only family law? To me, that's critical. I think I talked about that up front. You can't be good at something if you're not focused on what you're doing. If you see somebody who's doing bankruptcy, real estate closings, and divorce, avoid them. That's issue one. And I think the second issue is, do they have a big enough team to serve you? And family law is not a big firm area at all. It's not like you're suing, Federal Express or, General Electric where you need some huge law firm. Not at all. What we do need is probably you want one or two. You probably want a firm that has more than one attorney, and you probably want to make sure you kind of feel like there's good customer service happening, because I know from past experience, because I was in that circle probably 5 to 6 years ago where it was sort of just me and a very part-time assistant, versus now where it's me with 2 other attorneys and a full-time customer service person. The representation, purely the legal stuff, and also the pure, let's just say general customer service stuff is massively better and improved now that I have a team of attorneys and you have some full-time support staff. So those are just a couple quick nuggets. Got a little ahead of myself there, but second question, right? Should I file for divorce immediately? I think sometimes people misplay the urgency of this, and then what happens is if you file too fast, people going into court sort of flailing away because now we're in the court system and you're getting court dates and you have court involvement and you have stuff coming from the other party and maybe another attorney and stuff that just can be very wasteful, right? The court system, when used well, and it has to be involved, to differing degrees, but to just sort of file a case blindly and then just, whoa, now you're having court dates every month, oftentimes is not the best way to do it. And I do understand this issue. Sometimes it is an issue of you just want to kind of move forward. You want to look like you're actually making progress. So I certainly understand sort of the psychological idea of filing to just say, okay, I'm doing this, let's file the case. But I do see more the error of people just someday they get upset about something. I want this case filed tomorrow, and then without sort of having thought through some things. But then more to the stuff on this slide, I mean, to me, these are some things that are absolutely urgent where a case does need to be filed immediately. Somebody's grabbing a lot of money, right? You have a joint bank account with $50,000. Somebody just took half of it. I guess that would be the same as urgent financial needs. Maybe a house sale proceeds. That's a similar one. Just was dealing with a lady recently, actually she's a current client of ours, where in a sense she didn't even really want to file for divorce that quick, but we sort of needed a vehicle or a case to lock down some, a few $100,000 from the sale of a house. And so even though we may not proceed with the divorce, we needed something where court orders were locking down money and that kind of thing. So those are urgent issues. The grab and run with the kids and just cutting the other parent out in terms of parenting time, that's a big one too. Probably those top two almost. Domestic violence, obviously a serious and horrible thing that you see way too much in society. But to me, those first two are actually the triggers much more frequently in terms of, hey, you need to file your divorce case to get some oversight, basically some court oversight in those areas. Mom runs to another state, or even you get the other country with the kids and that kind of thing, or all of a sudden, hey, dad, you can't even if they don't run halfway across the country, it's like you're not seeing your kids anymore. So those are sort of the ones I would say, if those things are happening, that is a file the case situation. And can you weigh it? I think I sort of maybe exposed my bias a little bit, just in terms of being smart, because a lot of cases, right, if you don't have those top two or three things, really, what is the urgency? You want to be prepared. Have you spoken to an attorney? Have you talked to your spouse, right? Uncontested versus contested, meaning, can you work out 95% of the case before going to court and then just have one brief court date where, really that's the only court involvement, right? In a typical case that I'm calling an uncontested divorce case, I actually have one tomorrow morning. The case was filed in January, and now tomorrow, what is it, February 17th, we're having a final, very brief sort of summary in nature court appearance, because it's just totally uncontested, and it wasn't, this case actually wasn't the most simple thing going, but most of it was between the parties and they're negotiating, and now we're doing what we call sort of in the field an uncontested divorce prove up. Tomorrow morning, judgment will be approved by the court, entered as a judgment, and the case is over. So this is sort of a big question to consider, though. Do you have some of those urgent issues where it really is critical to file? And then the caveat that, look, if no communication, no kind of reach back from the other party, and you feel like you need to file it to kind of move the ball forward, that's all understood. But in a lot of cases, people are filing blindly and then sort of foolishly and not being smart in terms of approach. So third question is, what approach is right for you? This is probably one of the two, what I would say, most critical slides. I think just in looking through these and sort of reviewing them again, just sort of getting ready for the webinar today, because this is sort of like the idea of, are you climbing up the right tree, or what's the phrase sort of with a career? Are you, sometimes it's like, are you doing the right thing within a little circle? But then sometimes it's like, are you even in the right box for you? And this is sort of what I'm saying is sort of a real big picture upfront approach to think about. And the three ideas being, is this something that can be sort of an uncontested out of court deal? Is it something that's more of a middle path where there's some in-court negotiating and things of that nature? Or does it really have to be a real high conflict, real in-court litigating all the way? Because really the crux of these three boxes that I sort of put out there, and this is just from a lot of experience. It's not like these are real formal. These are the only ways to handle a case from, the Circuit Court of Cook County, Illinois, or wherever you are. This is just, frankly, from 13 years of experience broadly. These are sort of the three boxes I think about in a case. The first one just being uncontested out of court negotiating. And I think of this as sort of, if we're talking about a total continuum of, let's just say 100%, right, of what's the sort of most efficient and maybe most efficient in terms of time and resources being, let's say 1%, and least efficient use of resources as being the 99th percentile. In this circle here, right, uncontested out of court mostly, you're probably sort of in the, first to 20th percentile. Those were just some notes I sort of think about when I actually was just reviewing this on the train this morning. Right. A lot of this is between the parties. Sometimes both parties have an attorney, but the key thing here would be, you're not filing a case right away. You're sort of doing everything possibly you can outside of court, and then you're trying to put it in the box like the case I was describing a minute or two ago that I'm in court on tomorrow, which is then the only court involvement will be the final, what we would call the uncontested prove-up hearing. You're going to court once for an hour, case over, case ends quickly with an uncontested negotiated settlement. And right, there is obviously some differentiation within this circle here, and frankly between the complexity of the issues. But the common point is you're going to court once and you're generally not filing the case really until it's settled on the outside. So you're not sort of being driven by, sort of wasteful court dates that you're not setting, sort of like the automatic stuff that just happens once a case is filed. That being said, right, I certainly have these uncontested cases that are done in, at the very least, it might be 4 to 6 weeks. Some of these still could be a 6-month case. I mean, I'm just thinking about a case we just ended probably a month ago. Young couple, had very little. That case was over in a month. Conversely, but still an uncontested case, we had a gentleman who is was he a cardiologist, or strike that, an anesthesiologist, right? A medical doctor, I think, who does the anesthesia sort of in the hospital setting. Older gentleman, married with 2 older kids. So now you started to have, child-related issues that we didn't have in this one that ended in a month. And frankly, you had a lot of resources there. The guy's making a couple bucks when you're a medical doctor. And his wife happened to be a paralegal. So sort of this interesting setup where you had quite a bit of resources, and then the wife, who was actually really easy to deal with, but she was very fastidious, very detail-oriented. So I want to say, just thinking out loud, we went through about 6 drafts of, the different settlement documents. But all that to say is we still ended up going to court one time, and it was really a pretty efficient and intelligent use of their resources with the case, and I would say a fair result. Middle path might be sort of the situation where somebody feels like they have to move forward. They can't. They have, whatever. Somebody's being unfaithful. Somebody's being really abusive, and maybe in a physical or harassing sense. And it's like, I need to get out of this marriage. I need to file this case. You can't do all the out-of-court stuff. I get that, absolutely. So oftentimes that's sort of this middle path, because a lot of cases are sort of on that uncontested path, or in this middle path where you're filing a case. So now you have access to the court oversight. You have court orders. You're doing a lot of negotiating, lawyer to lawyer. Maybe you're sitting down with a judge for sort of a settlement conference if you're running into 1 or 2 issues that are sort of stopping you. And here, right, the case is ending eventually with an uncontested negotiated settlement over time, and this is probably it's hard to think of a percentage, but probably 60% of divorce or child custody cases are sort of in this middle path, where it's contested in the sense it's in court and you're going to court, maybe every other month or every 45 days or that kind of thing, but you're not ending with like a big contested trial where, hey, we're having 2 days where a judge is going to decide who gets custody of the kids, and how are we dividing all these assets, and it's somebody getting spousal support. That's sort of the path here is, maybe the judge is going to stick his or her nose into the case as sort of some final recommendations on some open issues, but you're not ending in a contested trial. And a lot of cases are like this. I can think of one of our best cases in the last couple of years that, they had some pretty significant resources where this needn't to be a bad or wasteful path, where, frankly, we were being smart and, thorough, but not wasteful as attorneys. The wife had a very good attorney, and frankly, it was with a judge out in DuPage County, who was one of my favorite in Chicagoland. It was also very just thorough, and she's pushing the case along and, giving her input as necessary. The biggest challenge in this middle path, really, and this is hard to control, really, the biggest X factors are really, does the opposing party have a decent attorney who's not going to be foolish and wasteful, and who's the judge on the case? And neither of those two things can you totally control. You can control the judge probably more easily than the other attorney, but it's a sad statement, but sometimes the opposing attorney being they're out there, right? I mean, I hate to say it, but they're out there, the people who just want to be wasteful, who want to churn a case, be wasteful, and frankly, right, these guys out here who get somebody signed up on some hourly rate. Hey, I'm getting paid $300 an hour. I might as well do work, whether it's to just benefit me as attorney versus, it's fine to do work and be smart as an attorney, but let's do some stuff that actually benefits the client's case. So sadly, that's the challenge in that middle path. That middle path is really a pretty good path on a lot of cases because, there are some sort of court-imposed deadlines and stuff if things aren't moving along. And then this last box, believe it or not, only 5% of cases in the Circuit Court of Cook County actually end in a final divorce where everything's fought over. A case ends with a contested trial. So, 95% of cases are not in this box. I think people have the misperception, everything's so contentious, da-da-da-da. I can think of one. I just made a note of a case of our cases that went on for a number of years that the end of it was this, but real world, and we probably have approximately 100 cases going on at any one time. I'm just thinking in an average year, how many trials do we have? It's probably less than 5. And honestly, probably only 1 or 2 of those, the only reason those are going to a trial is because you'll have some opposing attorney who's not very good or something, and sort of progress doesn't happen, and the only way to sort of put a period at the end of the sentence or to end the case is to have a trial date, because then you at least know it's done. So this should be avoided. It can't always be, right? I mean, if you can't talk to the other person, if they're abusing kids, grabbing money, and totally unreasonable, obviously that's why we have those 5 cases out of 100. And that's, like I said, that's an average coming from the head judge of the domestic relations division from just a couple years ago. I remember hearing that at a seminar, that only 5% get here. But right, I mean, that's going to be 2 or 3 years. It's going to be a lot of money. It's going to be a lot of court appearances. So think long and hard about approach, because this is sort of one of those things that you want to get the right track, because if you're on the wrong track here, it can really hurt you. I mean, it's not a little thing. This is sort of like upfront, strategic. What's the best way to approach things? 4th question, should you move out of the marital home? Just pull up these all. There's 4 points here. The substantive strategy on whether or not to move out of the home really is generally related to children. If they're kids, that is an important issue when you're talking about what we used to call custody or parenting time. Getting out of the house where now, if you're the parent who's out of the house, the other parent can say, look, this kid, he or she is not exercising much parenting time, versus, hey, you're there every morning at breakfast, or this kind of thing. That's really the real critical substantive play, where, if their kid's involved and your goal is maximum involvement, whether it be to win sort of the idea of being the majority time parent, or just having a real serious parenting schedule, you shouldn't move out of the marital home. Obviously, you have these situations where maybe there is mental or physical abuse, and where it's unavoidable, where, frankly, you can kick the other person out of the house if there is abuse or sort of mental anxiety happening. And sort of this first bullet point and this fourth bullet point are sort of more the financial play. Can you afford to move out? I think I was just listening to something this morning about, essentially, this was the tagline I remembered, though. It was where something like 1/3 of Americans who get divorced end up below the poverty line. So that's a big one, right? That upfront one there. Can you afford to move out, or can you delay it as much as possible? Or I'm thinking of a case we just wrapped up last week. This woman, fortunately, I think her mom lived in the same school district that she and her husband had lived in, so it was an easy move for her. This, forgetting her age, but mid-40s aged woman with a couple kids in the public school system where she was living, was able to just move in with her mom with little impact on her life or the kids' life. So the affordability issue is really a big, not really directly to the divorce, but sort of big picture moving forward. Divorce is going to be a financial crunch, so that's a big one. Can you delay it? I personally think more people can and should just remain in the home while they're going through things. Whatever, you're separated, somebody's living in the basement, such is life. But I'm just thinking about my own personal life, right? What's your biggest monthly budget line item? For me, it's our mortgage. So, if you can just delay that for 6 months to a year, that's quite a bit of money, right? So, and then this last bullet point, will moving out affect your interest in the marital home? The answer to that's no. It's marital property. If it's going to get sold at the end of a case, if somebody's going to have to refinance and get some cash out for the other party, possession is not a part of that at all. So, think through the financial ramifications, and then, like I said, the kids' issues are really important if you are talking about minor kids. This question 5 here, this next slide is going to be, how can I control costs and not waste time? This is probably the second slide that I would point to after, I guess it's question 3 that I just went to, sort of the idea of what's the smart upfront approach. And this question 5 is sort of another big one. Controlling costs, and what I would say, just what's the best way to handle the process? And here's what I'm talking about here is, I'm assuming, okay, if someone is going through with the divorce case, or the custody case, or right? I'm sort of talking about those two things. Obviously, we're talking about filing for divorce in the title of the webinar, but sort of the similar issues apply. And I think this is sort of profound. Something I've just learned over time is the 3 parts of a divorce case. There are 3 parts generically to a divorce case, and you can eliminate 2 out of the 3 quite easily, and save yourself a ton of time and money. It's not a trick. It's just sort of being intelligent about it. So here are the 3 parts, and just want to kind of think this through a little bit, and just tease this out a little bit. The end of a divorce case is going to be a judgment that includes property and financial matters, and it's going to be a judgment that includes child-related stuff if they're children. The final judgment there, bullet point, or, I guess line item number 3 here is important, especially if you have a lot of things that are going to live beyond the case, right? I mean, you're talking about things like, what's going to be the structure of your time with your kids? What's going to be your financial obligations with regards to your kids? Important issues. On the property side of things, how are investment accounts and retirement accounts and, the value in homes going to be divided? Important issues is, are things like spousal support, maintenance or alimony, what we would call it, in play. So what's in the final judgment is important, and I'm not trying to diminish that at all, because this is where the focus should be, is on number 3, because it's important. Here's the deal, though. Sometimes it's almost like there are 3 different cases within one case. And when possible, the way to be smart and to, frankly, save time and money is to eliminate the temporary stuff and to eliminate discovery or general investigating. And here's what those are. And I think I actually bring them out a little better in a couple of these future slides. You might want to reorder these for my future reference, just, criticizing myself there. But so, right, the final judgment in a case is, if you have kids, it's going to include things like child support and spousal support. And, sometimes one party has to contribute to the attorney fees of the other party. But sometimes it's like this stuff is being fought over for 18 months while the thing's in court, whereas, the advice is do your best to maintain the status quo without court involvement. That can be done. Somebody doesn't have to just stop, supporting the kids or paying the mortgage that, now your wife's living in, the home that your wife's living in. So, I mean, literally, this stuff can just be so taxing. And like I said, it's a case within a case. Temporary is just meaning, what are you doing? Temporary is just while the case before the final judgment's entered, whether that's, if it's 2 months, you're not going to be dealing with any temporary things. But, if this isn't going to be entered for 2 years, there might be a lot of temporary matters, but it doesn't have to be. This still might be entered a year or 2 into the future, but there's nothing that stops somebody from just sort of maintaining the status quo that existed during the marriage without any court involvement, and that's the recommendation. And then this circle is just, right, another sort of case within a case that's wholly able to be eliminated, though, is, what we call discovery or financial investigation, right? Making the other party turn over reams of, bank accounts and, I'm just thinking, what are the more exotic things? But, what are your interests in different businesses, and, show me your pay stubs. And it's sort of a classic thing that, frankly, I think some law firms like to do so much investigation. Look, it's one thing if you're talking about some billionaire with, 14 different homes and all these different companies and stuff. Once in a while, it really is necessary, but oftentimes, I heard this phrase at a seminar I went to recently. The phrase was the idea of, you don't have to boil the ocean to make a cup of tea. That's sort of the idea. We don't need to scour everything of a person's financial life for the last, 5 years to finish up and get a fair divorce judgment. So these two, number 1 and 2, are wholly things that needn't happen. Sometimes they do. I'm not trying to back off and say sometimes they don't need to happen. If I'm representing the person who has, the kids, and, dad's now cut off her from all financial resources, you got to do the temporary stuff. I mean, we just had a case where, we got temporary maintenance because this guy, this woman who's, disabled and it's basically no income. We got her, I think, $1,700 a month in temporary spousal support because it was necessary. She's sitting down in Atlanta, Georgia with some of her family because, this guy just cut her off financially. And then, number two, again, sometimes it is necessary. I can think of, again, an older woman who, just frankly, right, you see these situations, and that's when this isn't avoidable, and that's just a situation where one person's clearly the financial money manager, and now it's like, okay, we're having this marital breakdown, and now the other party knows nothing about the finances, and or they know nothing, or there's some, something more than just knowing nothing. They're just cut out. Hey, I'm not giving you passwords to stuff and this kind of thing. So then it has to happen, right? It absolutely has to happen. But I think in a lot of cases, these two, one and two, can be avoided. Let's get to the important stuff at the end of the case. Let's, if need be, fight about the important stuff about how things are going to be for the next, 5 or 10 years with your kids and spousal support and stuff, and not flail around on items number 1 and 2 here. Just to move along, though, I've got probably about 20 minutes left here. Do you know your financial situation? And that's sort of probably going back to just thinking about, is this in the correct order that it should have been? That's sort of the idea of that middle category there, and how to avoid being wasteful and sort of that legal research and investigation stuff. This is sort of how you avoid being wasteful in that category. Do you have access to financial information? Do you have a budget? And I'm thinking, currently, but also think about that post-divorce too. And then just sort of doing your homework, thinking about the future in a big way. If you've been a stay-at-home spouse, will you need to go back to school? Should you get a job? Should you look for a better job now or after a divorce? Just sort of creating a vision for your future, because, the reality is a divorce is a breaking up of what is partially a financial partnership. And even though, right, a lot of what we talk about in the law, Illinois, law in terms of the goals and bigger purposes of the law that sort of undergirds divorce is sort of putting the parties in a position they'd be in if they stayed married. The reality is you can't do that because now you're cutting, this financial circle in half. This is a tough question, though, in terms of spousal support, and somebody, if they have been the parent who's maybe the homemaker or the person who's staying home with the kids, should you get a job while the case is going on? That's a real tough one. I'll be honest, because it can, on the one hand, it can hurt the case for spousal support, or what we call maintenance now. If your income looks like it's zero and now it looks like your income's $40,000 a year, that's probably going to impact what you're getting going forward. So I think in your best case, you can sort of bide some time for 6 months to a year, maybe live with a parent, maybe get some short-term loans from somebody. So you're sort of staying in the position that you were in for the purpose of getting more spousal support going forward. But I guess if you have to, you need to get a job, and you sort of need to be prepared for the worst going forward, regardless. Because more of the picture of, is somebody entitled to spousal support, or is somebody entitled to maintenance or alimony in the future, most of that is predicated on what was the picture of the parties while they were married. In other words, who was the higher income earner, who had the, frankly, the training and the education and the job skills, and who was in fact being the higher and main breadwinner over the last 15 years versus, what's happening for that maybe, let's just say, 1 year while the case is going on. So most of that picture really is looking back at what was the standard that was established while you guys were married. But that is probably the hardest question to sort of mull around a little bit. And the reality is there isn't a black and white answer to that question of should you sort of try to ramp up your income, while you're going through a case or not. That's a tough one. If you have to, you have to. But I think if you don't have to, it's best not to. So last couple questions, and then I just have a bonus slide, and I can be available for questions, or we can take those offline. Um, give out my info. I think it's on the last slide. Should you move on romantically or before the divorce is final? So I'm not really giving sort of dating advice or something. Actually, more just talking about some things that do impact directly sort of the legal part of the case. There's nothing. This first one, before actually the first of this year, there were 10, or was it 12? You hardly even used all of them anyways, but you had 10 different grounds, or what we would call synonym would be reasons that the law provided that somebody could get divorced. One of them was what we would call the no-fault grounds. You had to live separate and apart for 2 years, and then you could get divorced. Or you could say, if in fact it were true, there were different fault grounds: mental cruelty, habitual drunkenness, abandonment, adultery. I mean, I hardly have them memorized because you really never use them. Once in a while, you use mental cruelty. But so, statement there is fault has nothing to do with things like, does somebody have to pay spousal support? Is how is property going to be divided? Fault has nothing to do with that. So the idea of, okay, if I have a new significant other even before the divorce is finalized, is that going to be a negative in the case? Excuse me, not in terms of those direct financial issues, absolutely not. Here are the two substantive ways that sort of having the new woman in your life, I mean, I'm a guy, would potentially impact a divorce. This second bullet point, if the court finds that you have used marital assets for a purpose not related to the marriage, there's a word I don't like to use legal words that the non-lawyer typically wouldn't use. But there's a word called dissipation, I think, which means waste. I mean, whether it's in family law or elsewhere. If you're using the marital estate for, buying a new car for a new significant other, that's going to bite you in the butt, and that's something to avoid. That's a substantive way that a new significant other can have on a case. It doesn't come up too often, but I was just thinking out loud of a couple situations recently where we had some guy who was gambling away half of the resources that he and his wife had made over the course of, I'm forgetting the length of the marriage, but it was more than 10 years. So if you're being wasteful in that regard with a significant other, or the weekends to Mexico, or like I said, the car, that's going to be a big problem. And the last one probably is the one I see most often of those two, ramifications on parenting matters. And that would just sort of be where there's an inappropriate introduction of a new significant other to kids who are, just, and I'm involved in this a lot, but I'm not sort of a social scientist, psychologist, to the point where, I can describe this quite as well, but, there are apps, that's where it comes up a lot in our cases, is, sorry, I just got distracted for a second there. A new significant other is being introduced to a 5-year-old kid, and it's kind of like, is this my new mom? You get this fought over a lot. Who's being called mom, who's being called dad. That kind of stuff can really hurt in sort of the child custody parenting time stuff, where it's kind of like, your kids are getting messed up because they don't know what or who this new significant other is. And specifically, it's people who are introducing a new significant other too early. I mean, I hear that a lot. I mean, and we often will include that in a custody judgment or something in terms of, how soon or not soon. Sometimes it's often, up to 6 months where, a new significant other cannot be introduced to these kids. So should you move on romantically before divorce is final? The answer is generally it's a non-issue in terms of the substance of the case. But it is an issue if you're talking about wasting assets, and it is an issue if there's an inappropriate sort of introducing of a new significant other to young kids in particular. Okay, so 8 things to consider before filing for divorce in Illinois. Final question, is there physical or emotional abuse? So I think the point or two that I just wanted to bring out in this last slide was really sort of the possession of a house issue. Can you make an abusive spouse move out? Believe it or not, sometimes getting the other parent or the other spouse out of a house is actually sort of a good strategy if you want to get custody of your kids. Frankly, it's often an abused strategy too, where people file sort of bogus orders of protection to just get somebody kicked out. So it's like, okay, he or she's gone, and now I'm the majority parent, and I should be awarded, primary custody of the kids because he doesn't even live here. So sometimes it's a custody strategy to consider, but it can backfire. I mean, if it is totally bogus, and you do see a lot of bogus ones. An order of protection, or there's another provision in the Illinois Marriage and Dissolution of Marriage Act that does talk about sort of mental well-being of the parent or the children in terms of there are proper situations where possession of a home can be awarded, and those are things to consider. So let me close with this final slide. I'm seeing about 5 to 1 Chicago time. Just some nuggets and common stumbling blocks. I'm going to put them all out and then maybe focus on 1 or 2. I think I spoke about this real early in the presentation, just sort of the inefficient use of your lawyer in court proceedings. Real early on, I just talked about the idea that your lawyer shouldn't be sort of your emotional best friend sounding board. Your lawyer should be the legal strategist, the person who's representing you in the court system, thinking through a lot of this strategic stuff and all that. So that's one thing, because it's probably the worst. Bad, let's just put it this way, it's bad for everybody when I'm just thinking of clients of ours who are they're calling you all the time about things that just are non-issues, they're not substantive, and it's like, wait, now at the end of the month they're getting this huge bill, and it's like, you can't be calling us every other day about total things you should be talking with your best friend about. So that's a big one. Not doing your homework. There's no such thing as lawyer magic. That was a term of art I think a law school professor gave me. But here's the deal, and I think some people, maybe they get their knowledge of what a lawyer is or does too much from TV, because in this part of the practice of law, family law, there's clearly stuff that we're doing as a lawyer. We're going to court, we're preparing court pleadings, and we're doing a lot of sort of big strategic thinking and counseling on, here's the law, and sort of applying it to people's situations. But factual stuff is absolutely sort of thing that has to be coming from the client. We have to be getting proofs of, tax returns and earnings and, the values of a home, values of a car, what's going on real world with kids. And I think, like I said, I feel like on TV people think, and I think this might be true a little bit, maybe in criminal law or something, where it is kind of almost everything's done by the lawyer sort of in the court system. But in divorce and child custody cases, it's absolutely kind of like we're doing these kind of things, the legal strategy stuff, but the client has to be doing sort of the helping out with the factual stuff and turning over documents and that kind of thing, because that delays things surprisingly frequently. Not knowing the finances, having access to documents. But yeah, I would emphasize, I think most of these others we've spoken about a little bit already, but inefficient use of a lawyer, not doing your homework in terms of getting stuff to me as your lawyer, those are huge deals in terms of nuggets and just stumbling blocks and just sort of wastefulness, just not the best way to handle a case. So I'm going to leave it there. I've got, I think, 12:59 on the clock, Chicago time. If you have any questions, here is our main number. Here's my personal email address. I'm absolutely happy to stay online for a minute or two here. I have a commitment probably in about 15 minutes, but you can certainly email me questions, and I would just reiterate. Well, and I would, just to track back for a second, if you want a copy of the slide package, shoot me a note or give us a call. Happy to give that to you as well. And just going back to our website quick, again, just kind of closing up here, final minute. We do free initial consultations. That's probably the best way. If you have something really individual or practical that you need answered, we sit down with people and really dig in for 45 minutes and make it sort of what we plan for and what the expectation is. But that's no charge. We like to do those in person at our downtown office, or we have a couple suburban locations if you're out in the burbs. Worst case, if you're really inflexible, that can be a telephone conference. But I would encourage you to do a free initial consultation, because right, it's just sort of information from legal experts on how to best approach things. So I'm gonna say thank you to everybody for joining the webinar today, and just emphasize, I've been doing this a while. I'm really passionate about being a pro-family divorce and child custody attorney, because people shouldn't be pushed out of their kids' lives just because of a breakup. And divorce and custody cases should not destroy somebody financially. It's a tough deal, but some of these situations where people get ravaged and taken advantage of, that's just wrong. And that's not how we are. We're absolutely just trying to be a great value proposition sort of in the family law space. I say this sort of kiddingly, and because I'm not a car guy at all, but we're really sort of trying to be the Toyota Camry of family law firms. And what I mean by that is just this. We are not representing CEOs and professional athletes, but when you're talking about sort of people in the $50,000 to $150,000 range, I would suggest we're the perfect attorneys for working and middle class people. The firms who are representing the CEOs and professional athletes, they're probably a lot better at doing that than we are. But you know what? We're a lot better at as a value proposition and in terms of the legal work and the specific issues to sort of middle class people than those people are. We have real unique focuses on. We have Spanish attorneys and Spanish support staffs, and just like I said, really representing small business people, Christian community around Chicagoland, and just middle class people. So Thanks for being on the call. Look forward to serving you. And yeah, schedule a consultation. Happy to help you. Again, Attorney Peter Olson here, Chicago Family Law Group. Thank you.